Mr. Conn. How are you? I'm showing that we have no cases to reconsider under agenda item 3. Is that correct?
That is correct. There are no cases under agenda item 3.
Thank you. Let's now consider tax liability cases under agenda item 4. Good morning, Ms. Turner.
Good morning.
I believe we have tax cases on docket 7 and 8.
Yes, sir. Y'all have 4 cases for docket 7 and 4 cases for docket 8. The first case on docket 7 is TD 181831018. Commissioner Demerson.
I agree with staff recommendation.
Commissioner Alvarez.
I disagree with staff's findings that these workers are not in employment. The employer in this case is in the business of supplying painters, cleaners, granite installers, plumbers, and tile installers. Therefore, all of these workers are fully integrated into its business. The employer's clients schedule the workers, and any direction and control asserted by the employer's clients is imputed in the employer. The employer is providing all of the materials and the use to perform the work. These elements indicated that the employer does exercise direction and control over its workers, and they are in employment. In the alternative, only workers who have separated business entities have their own employees, and a substantial investment in equipment should be considered to be independent contractors.
Chairman Daniel.
Agree with staff recommendation.
Short form dissent.
TD 190200119. Commissioner Demerson.
Agree with staff recommendation.
Commissioner Alvarez.
I agree with staff's recommendation that the LLC member and administrative worker are in employment. But I believe the roofers and laborers in employment are in employment as well. The employer is a roofing company, so the roofers are fully integrated into the business. The employer admits to supervising the work of the workers. The workers are paid weekly and biweekly rather than being paid at the completion of the job. There is no evidence that roofers have their own business, that the roofers own their own business or substantial investment in businesses, and all materials to complete the work is being provided to the roofers. With regard to the laborers, there is no evidence that the laborers have their own business or any investment in the business. The work performed is integrated into the roofing service offered by the employer, and the nature of the general labor is that of the employer must direct the work regarding what tasks to be completed.
Chairman Daniel.
Agree with staff recommendation.
Short form dissent.
TD 191311119. Commissioner Demerson.
I agree with staff recommendation.
Commissioner Alvarez.
I agree with staff's recommendation.
Chairman Daniel.
Agree with staff recommendation.
TD 191381219. Commissioner Demerson.
I agree with staff recommendation.
Commissioner Alvarez.
I agree with staff's recommendation.
Chairman Daniel.
Agree with staff recommendation.
Docket 8. First case is TD 191130919. Commissioner Demerson.
I agree with staff recommendation.
Commissioner Alvarez.
I agree with staff's recommendation.
Chairman Daniel.
Agree with staff recommendation.
TD 191211019. Commissioner Demerson.
I agree with staff recommendation.
Commissioner Alvarez.
I agree with staff's recommendation.
Chairman Daniel.
Disagree with staff recommendation. Both occupations are not employees.
So did you want a short form?
Yeah.
Sorry.
I'm going to go ahead and agree with the chairman on that.
Okay, Commissioner Alvarez.
Short form dissent.
191301119. Commissioner Demerson.
I believe there's insufficient information in tax department records and in the proposed decision to conclude that the named company is a limited partnership and that the vice president is a partner of the partnership. The company named itself is styled as a corporation with the limited partnership as a DBA of the corporation. However, the employer master file contains an ownership code of 02 for the entity, which is used for partnerships. I suggest we have this case resubmitted on a later docket with a detailed analysis of what the nature of the named entity is, i.e. whether it is a corporation or a partnership. That information will help determine the status of the vice president.
Commissioner Alvarez.
I agree with staff's recommendation.
Chairman Daniel.
Agree with staff recommendation.
Short form dissent.
TD 191391219. Commissioner Demerson.
I agree with staff recommendation.
Commissioner Alvarez?
I agree with staff's recommendation.
Chairman Daniel?
Agree with staff recommendation.
Thank you.
Ms. Turner, I have a note here that says this is your last meeting in this role, that you're accepting a new assignment with the agency. Is that correct?
That is true, yes.
Well, it has been an absolute pleasure working with you in this capacity. I look forward to much success from you
Thank you very
as you
much.
pursue your new adventure.
Okay, thanks.
Thank you.
Congratulations.
Thank you.
Ditto.
So then we'll move to agenda item 5. We have no fair housing cases under agenda item 5. Is that correct?
That is correct.
Okay. Moving to agenda item 6, we have no wage claim cases pulled for additional discussion on docket 7 and 8. Is that correct?
That is correct. There are no wage claim cases pulled. You will now receive the wage claim short form dissent list for dockets 7 and 8.
I move we accept staff recommendations on the remaining wage claim cases on docket 7 and 8.
I second the motion except for those cases on which I am dissenting, as reflected on the wage claim short form dissent list for dockets 7 and 8.
I concur with the chairman's motion, except for the cases on which I am dissenting is reflected in the wage claim short form dissent list for dockets 7 and 8.
Motion passes with the exceptions noted. Let's move to agenda item 7, consideration of unemployment insurance cases on docket 7. You can proceed when you're ready.
Beginning with case 242-7432, Commissioner Demerson.
The AT decision should be affirmed. Although the claimant asserts that he was discharged, the weight of the evidence establishes that he quit. First, the claimant's resignation letter in Exhibit 1 clearly states that he quit to accept another job closer to family. The claimant's explanation that he submitted this resignation after he was discharged is neither credible nor persuasive. There is no reason for the claimant to carry around a resignation letter in his pocket with the specific last day of work if he was not planning on quitting. In addition, the employer testified that the claimant submitted his resignation letter to the employer as well as to the client company. The claimant did not deny this, and this further supports the employer's position that the claimant did not request further work after he separated from the client company. The claimant also altered his testimony after the employer testified, rendering his statements unreliable, and there's no evidence in the record that supports the claimant's version of events. Ultimately, since the evidence shows that the claimant quit the job and there is no indication that he had good cause to do so, we should affirm the AT decision, voluntary leaving, no chargeback.
The decision should be reversed. The claimant was discharged because the client manager determined that it was not working out. However, the employer did not provide any evidence of misconduct. Additionally, the claimant's submission of a resignation letter after he was discharged does not change the nature of the separation. Further, the employer did not provide the claimant with written notice that he was required to report for the reassignment, and as such, 207.045H does not apply, and the claimant was not required to report for additional work. While the employer has alleged that the claimant was not fired, the employer has not provided firsthand testimony on this issue. At the scheduled rehearing, the employer explicitly stated that they did not believe that the client manager was likely to participate. Therefore, the decision should be reversed, no misconduct, chargeback.
Affirm the AT, voluntary leaving, no chargeback.
Short form dissent.
243-6904, Commissioner Alvarez.
The AT decision is not supportable. The claimant provided the only testimony in the AT hearing. She suffers from multiple medical conditions, include the need for knee replacements and neck surgery. She has also suffered a heart attack. The claimant's job as a cashier required standing for long periods of time. On her last day after working 5 consecutive shifts, she asked the manager to leave early because of severe pain from standing. She was told by the manager that he did not want to hear about it and was not given permission to leave. After waiting until she could no longer perform the job, the claimant clocked out to go home. She was discharged on the following day. The employer refused to accommodate her reasonable request to leave work early when the claimant was in severe pain, and the claimant's actions did not constitute misconduct connected with the work. Reverse the AT, no misconduct. Employer is a party of interest.
We should modify the appeal tribunal decision because the claimant left work without authorization and without notifying her supervisors that she was leaving for the day. The claimant mismanaged her position of employment. We should modify the AT decision, misconduct. The employer is a party of interest.
Modify the AT, misconduct, employer is a party of interest.
Short form dissent.
243-8253, Commissioner Demerson.
The AT decision should be modified. As to good cause, the owner credibly established non-receipt of the hearing notice, as he only learned of the hearing once his tax manager received a call from TWC. Thus, good cause was established, and the case should be resubmitted for merits testimony. If my fellow commissioners disagree, the case should still be modified on the job separation, since the claimant's testimony is self-disqualifying. The claimant admitted that on the final incident date, she was not in the office ready to work. Instead, upon arrival, she promptly left the office, locked the door, and went downstairs to have coffee and breakfast while on the clock. Closing the office during business hours without permission is inappropriate and constitutes mismanagement of one's position of employment. As such, we should modify the AT decision. The employer did not have good cause for its non-appearance, misconduct, overpayment of $1,035.
The decision should be affirmed. The employer's testimony established that when the owner is out of the office, there is no set process for handling the mail. Therefore, the employer did not overcome the presumption of receipt and did not establish good cause for their non-appearance. Regarding the job separation, the claimant was laid off when the employer closed the San Antonio office. The employer's allegations that the claimant was tardy is simply pretext. The claimant arrived at work on time and was getting coffee during a 15-minute break, which was customary for the claimant and coworkers. As such, the claimant was laid off due to a lack of work. Affirm the AT, no employer good cause, no misconduct, no overpayment.
Reverse the AT. Employer established good cause for AT1. Resubmit.
243-9357, Commissioner Alvarez.
The decision should be modified. The claimant's appeal to the July 26, 2019 determination was late. However, the ineligibility closure should have been left in effect. When the claimant initially filed her claim, she indicated that she would no longer perform her last job duties because of her back injury. However, the claimant provided medical documentation that she had been released to return to work with restrictions. These restrictions included taking a break from sitting every 2.5 hours. The claimant has experience in retail, call centers, and HR. She was searching for work in these fields, and there are positions in these fields that the claimant could perform with her medical restrictions. The AT decision is discriminatory and fails to account for any employer legal obligation to provide reasonable accommodations. As such, the decision should be modified. The claimant filed a late appeal. The claimant was unable to work beginning July 7, 2019. However, the determination closing the ineligibility July 13, 2019 should be reinstated.
We should affirm the appeal tribunal decision. Regarding timeliness, the claimant failed to file a timely appeal despite opening the determination only 2 days after it was sent to her. As such, the claimant's appeal is not timely. However, we can take continuing jurisdiction of the open period ineligibility effective August 15, 2019. The claimant provided individual fact-finding statements for the current ability issue, as well as for the job separation issue involving the named employer. In separate statements, she provided for both issues. She stated that her back injury only allowed her to work part-time and not full-time. Since these statements were provided closer in time to the discharge, they should be given greater weight than her later statements. Accordingly, in the absence of medical documentation changing the claimant's medical restrictions, it was appropriate to hold the claimant ineligible beginning July 7, 2019. We should affirm the AT decision. The claimant filed a late appeal. The claimant was not able to work beginning July 7, 2019. Void the determination, which closed the ineligibility on July 13, 2019.
I would concur with Commissioner Demerson.
Long form dissent.
244-5231, Commissioner Demerson.
The AT decision should be affirmed. The claimant testified that she quit due to the working conditions and due to a medical issue. Regarding the working conditions, the claimant's supervisor testified that he had addressed the claimant's concerns about her manager. Furthermore, the record does not establish that the working conditions were intolerable. As to the claimant's medical issue, there is no medical documentation showing that the claimant was advised to resign, nor did she testify that she was instructed to do so by a physician. In fact, a doctor's note from the date the claimant quit indicates that the only limitation on her ability to work was a lifting restriction. There is also no evidence that the claimant requested accommodations such as a stool, different shoes, additional breaks, or other reasonable modifications of her job duties. Based on the evidence, an MVI would not be appropriate in this case, and the claimant quit without work-connected good cause. We should affirm the AT decision, voluntary leaving, no chargeback.
The AT decision should be modified. The claimant quit the job due to her medical condition. She provided credible medical documentation to the AT of her back problems and has consistently maintained that her medical condition led to her condition to quit. She worked as an assistant manager in a position that required a lot of standing and walking. And she had documented back problem that was aggravated by her job. She also requested from the employer to go back to a prior position because of her condition, but her request was denied. The claimant quit due to her medically verified health condition and should not be disqualified. Modify the AT, no voluntary leaving, no chargeback due to MVI.
I concur with Commissioner Alvarez.
Short form dissent.
244-7098, Commissioner Alvarez.
The decision should be reversed. The claimant had thyroid cancer. She turned in numerous notes from her doctors regarding her medical condition. The hearing packet has numerous copies of doctor's notes. I understand that the employer in this case was dissatisfied with notes drafted by the claimant's doctor, but the failure of the claimant's doctor to state how long her illness would last does not mean that the claimant committed misconduct connected with the work. Reverse AT, no misconduct, void reimbursing ruling.
The appeal tribunal decision should be affirmed. Despite multiple extensions and opportunities, the claimant did not provide the employer with the information it requested to excuse their absences. As such, the claimant did not take adequate steps to protect her job, and we should affirm the AT decision. Misconduct, void reimbursement ruling.
Reverse the AT, no misconduct, void reimbursement ruling.
Short form dissent.
244-7574, Commissioner Alvarez.
The decision should be modified. I agree that the employer had good cause for its non-appearance because the VP called at the correct time in his time zone, and his call to the hearing officer's direct line was a good faith effort to participate. With regard to the job separation, the claimant provided sworn testimony that he was not told that 3 employees were acting suspiciously and seemed to be under the influence until after the shift ended and the employees had left. The claimant's testimony was consistent with prior statements and corroborated by another first-hand witness. The employer provided a first-hand witness, but the witness's testimony had to be prompted by leading questions from the employer's primary representative. The unprompted testimony of the claimant and his witness carries greater weight. The evidence is insufficient to establish misconduct. Reverse AT, employer had good cause for its non-appearance, no misconduct, chargeback. In the alternative, the claimant's due process rights were violated by the AT failure to maintain control of the hearing, and the case should be reheard so that he can testify without being interrupted, badgered, or belittled.
The appeal tribunal decision should be modified. I agree that the employer had good cause for its non-appearance. As to the job separation, the claimant acknowledged that he received an email from the employer outlining its after-hours drug testing procedures. Nonetheless, the claimant did not act in a manner consistent with the employer's policy. As such, the claimant mismanaged his position of employment. We should therefore modify the AT decision. The employer had good cause for its non-appearance, misconduct, no chargeback, adequate employer response.
Due to the hearing officer's failure to control the hearing and to avoid any possible due process violations, this case should be remanded de novo. I would also like a briefing on customer service processes and why this case was allowed to reach this level of appeal without any other action being taken.
I would agree with the chairman.
We'll remand this case.
244-8365, Commissioner Demerson.
We should reverse the appeal tribunal decision. The claimant was discharged for engaging in inappropriate behavior in text messages he exchanged with the civilian. A review of all the text messages submitted by the parties indicate that the civilian was initially a willing participant in the exchange of messages. However, at some point, the conversation took a turn, and the civilian asked the claimant several times to stop sending her pornographic messages. The claimant's initial response indicated that he was not willing to comply with the request, and he later progressed to making indirect threats against the civilian. Because the employer's policy addressed a police officer's conduct while both on and off duty, and the claimant's actions violated this policy, the claimant mismanaged his position of employment. Accordingly, we should reverse the AT decision. Misconduct, reimbursing employer not billed, adequate employer response.
The AT decision is supportable. The claimant was let go from his probationary period of employment because he missed too much training while the employer investigated a complaint from a member of the public. The employer drew no conclusions regarding the claimant's culpability and let the claimant go at their convenience. Affirm the AT, no misconduct, bill reimbursing employer.
Reverse the AT, misconduct, reimbursing employer not billed, adequate employer response.
Short form dissent.
244-8849, Commissioner Demerson.
The AT decision should be reversed. The parties agreed that the claimant, a school district superintendent, was on paid administrative leave when he was proposed for termination. However, before the board can conduct a trial on the termination proposal, the claimant resigned from his position. The termination decision was not final at the time the claimant separated from his employment, as the review process was still underway. Thus, the claimant was not discharged. He quit in anticipation of discharge. Accordingly, this case should be rendered under Section 207.045 of the Act. Since quitting in anticipation of discharge does not constitute good work-connected cause for quitting, we should reverse the AT decision. Voluntary leaving, reimbursing employer not billed, adequate employer response.
The AT decision should be affirmed. The claimant had been appointed to the position by the superintendent as a result of the school district's accreditation issues with DEA. The claimant was involuntarily separated when he was given the choice to resign or be discharged. The employer's board was dissatisfied with the claimant's performance because they did not feel that the school district was improving fast enough. The employer did not provide any direct firsthand evidence of misconduct by the claimant. The claimant's testimony credibly established that he was working to the best of his ability. Affirm the AT, no misconduct, bill reimbursing employer.
Affirm the AT, no misconduct, bill reimbursing employer.
Short form dissent.
244-9124, Commissioner Alvarez.
The AT decision should be modified. On the good cause, the AT correctly ruled that the claimant had good cause for his non-appearance at the AT1 because of phone problems outside the claimant's control. On the separation, the AT decision should be reversed. The claimant takes a number of medications for serious mental health problems. He was not able to continue working in his position because of his health condition. He has since had his medication adjusted and is able to work. The claimant quit due to medically verified illness. Modify the AT, good cause for his non-appearance at AT1, no voluntary leaving.
I would affirm the AT decision. I do not contest the good cause finding. As to the job separation, the claimant initially stated that he quit due to a lack of transportation, which is a disqualifying personal reason. Regarding the claimant's medical condition, he did not seek medical treatment before he quit, and the doctor did not advise him to resign. Thus, the claimant did not meet the requirements to establish that he had good cause to quit, and we should affirm the AT decision. The claimant had good cause for his non-appearance, voluntary leaving.
Affirm the AT, good cause for claimant to miss AT1, voluntary leaving.
Short form dissent.
245-0817, Commissioner Alvarez.
The decision should be reversed. The regional operations manager testified that the claimant was told that a truck had been idling too long. The truck was off-site, and the excessive idling led to damage. The employer did not provide the first-hand sworn testimony from the individual who allegedly provided this information to the claimant. The employer did not even provide the name of the person who allegedly told the claimant about the truck. The claimant denied being told that the truck had been idling too long. The evidence is insufficient to establish misconduct connected with the work. Reverse AT, no misconduct, charge back.
The appeal tribunal decision should be affirmed. The claimant was discharged for poor job performance. Regarding the final incident, a driver reported to the claimant that a technician might have been asleep in a one-ton truck. The claimant did not investigate. The driver later told another employer about what had occurred, and after an investigation, it was discovered that the truck had been idling, which ultimately cost the employer over $5,000 in repair costs. Per the claimant's fact-finding statement, she was responsible for disciplinary action, and her failure to investigate the driver's report especially while on a performance improvement plan, constituted mismanagement of her position of employment and misconduct connected with the work. We should therefore affirm the AT decision, misconduct, no chargeback.
Affirm the AT, misconduct, no chargeback.
Short form dissent.
2451385, Commissioner Demerson.
The appeal tribunal decision should be modified. The claimant was discharged for what amounted to poor job performance. The claimant was responsible for sending emails to employees to notify them about matters concerning certification compliance. It is not unreasonable to classify sending emails as a non-complex task. Indeed, the claimant stated that she thought she had sent the emails, but when asked for proof, the claimant admitted that she was not able to provide any. Since the claimant contends that she sent the emails but did not provide any corroborating evidence in support, the employer's evidence should be given greater weight. We should therefore modify the AT decision. Misconduct, the claimant did not have reasonable assurance.
The decision should be affirmed. The claimant worked for the employer for less than 3 months. The claimant was working to the best of her ability, but she was unable to perform to the employer's standards. The claimant's inability to perform to the employer's standards was not misconduct connected with the work. Affirm the AT, no misconduct, no reasonable assurance.
Affirm the AT, no misconduct, no reasonable assurance.
Short form dissent.
2453460, Commissioner Demerson.
We should reverse the appeal tribunal decision. Despite being warned about accuracy in her work, the claimant entered an incorrect patient number, which associated an X-ray to the wrong patient's file. In addition to causing a delay in patient services when the physician tried to find the correct image, the claimant's error resulted in a HIPAA violation. Because the claimant's error could have been avoided had she carefully checked her work as she entered patient data, and this was something well within her power to control, the claimant mismanaged her position of employment. We should reverse the AT decision, misconduct, void the chargeback ruling.
The decision should be affirmed. Despite working to the best of her ability, the claimant was never able to perform to the employer's satisfaction. The claimant was never able to keep up with the high volume in the practice, and the employer failed to train the claimant on how to fix data entry errors. The claimant's inability to perform to the employer's satisfaction was not misconduct. Affirm the AT, no misconduct, void chargeback.
Affirm the AT, no misconduct, void chargeback.
Short form dissent.
2455319, Commissioner Alvarez.
The named employer in this case is a predecessor account to the named employer in the companion case. There is no dispute that the claimant worked for the employer, and there is no dispute regarding the amount of wage credits. The only issue is that the claimant's wage credits were mistakenly listed under the predecessor's account. As such, the AT decision should be modified to note that the claimant did not have wage credits from the predecessor account.
This case should be resubmitted with reliable information from the tax department. The field tax comments from the account of the entity named in the companion case indicate that the entity in this case was but one of several predecessor entities, and that wage credits reported by the employer in this case was deleted as duplicative. However, it appears that the claimant's legitimate wage credits may have been erroneously deleted from both accounts. Clearly, the claimant should have some wage credits from her work for one of the named employers. She should not have to show wage documentation that was already reported by both employing units. We have the information needed. Our Commission Appeals Department simply needs to get it from the tax department. Accordingly, we should obtain the necessary information from the tax department concerning the wage credits that should not have been deleted, and have this case resubmitted with proper attribution of the wages as reported by the employer that employed the claimant.
I concur with Commissioner Demerson.
2455324, Commissioner Alvarez.
My comments are the same as the companion case. The claimant's wage credits were mistakenly reported under the predecessor account number. As such, the AT decision should be reversed to award wage credits under the named employer in this case. Because this case concerns a successor account. Reverse AT, the claimant had wage credits of $1,733.28 for the second quarter of 2018, $22.98 for the fourth quarter of 2019, and $3,551.34 for the first quarter of 2019.
Comments same as previous, but accordingly, we should obtain the necessary information from the tax department concerning the wage credits that should not have been deleted, and have this case resubmitted with proper attribution of the wages as reported by the employer that employed the claimant.
I concur with Commissioner Demerson.
We'll resubmit these two companion cases after consulting with the tax department.
Okay.
2456065, Commissioner Alvarez.
The AT decision should be reversed. The employer began investigating the claimant for the final incident 4 months before the discharge. The employer provided only a vague explanation for the long delay before she was let go. The claimant credibly testified that the investigation had been closed at the time that she had filed a complaint against her supervisor with HR in July of 2019. After her complaint, the investigation was then revived and she was discharged. The claimant credibly testified that she did not intentionally alter financial documents and believed, based on information from coworkers, that the designator that she added was only for internal use. The employer's witness did not offer a clear explanation for why exactly the designator that the claimant added to the document would constitute falsification or prohibited altercations of records. Given these facts, the evidence was insufficient to establish misconduct by the claimant. Reverse AT, no misconduct, chargeback, void adequate response.
We should modify the appeal tribunal decision. The claimant altered documents that had been signed by a client without first notifying the client or obtaining client authorization. Because the claimant was not supposed to unilaterally alter such a document and she was aware of the employer's policy, the claimant mismanaged her position of employment. As to the delay in discharge, the employer explained the reasons for the delay. Number one, the employer had to thoroughly investigate the matter. Two, there were complex regulatory issues to navigate through. And three, the employer needed to investigate the claimant's allegations of retaliation before making a decision on her discharge. Accordingly, because the discharge was not too remote in time, we should modify the AT decision. Misconduct, no chargeback, sever the adequate response issue.
Modify the AT, misconduct, no chargeback, sever adequate response.
Short form dissent.
2457267, Commissioner Demerson.
The appeal tribunal decision should be reversed. The claimant admitted to directing an employee to tell a coworker to get away from the claimant's car. Although the claimant stated that the ex-employee to whom he gave the directive was not an associate or a friend, his statement is not persuasive. The person apparently knew the claimant well enough to know what kind of car the claimant drove and to have the claimant's phone number. By telling an ex-employee to notify a coworker to get away from his car, the claimant set in motion a chain of events that led to the coworker being confronted with a pistol. As such, the claimant's actions constituted misconduct connected with the work. We should therefore reverse the AT decision. Misconduct, no chargeback, adequate employer response.
The decision should be reversed. The claimant was discharged after a former employee pulled a gun on one of the claimant's coworkers. The claimant was not present for the incident that led to his discharge. He was away from the facility making deliveries. The claimant did not ask for the former employee to come to the work site. The claimant did not ask for the former employee to pull a gun on the coworker. The claimant is not responsible for the actions of a third party. The evidence is insufficient to establish misconduct. Affirm the AT, no misconduct, chargeback.
Affirm the AT, no misconduct, chargeback.
Short form dissent.
That brings us to the end of the pulled cases for docket 7. We'll move on to the pulled cases for docket 8 now. Oh, we'll pass out the short form dissent list for docket 7.
I move we accept staff recommendations on the remaining UI cases on docket 7.
I second the motion except for those cases on which I am dissenting as reflected on the UI short form dissent list for docket 7.
I concur with the chairman's motion except for the cases on which I'm dissenting as reflected in the UI short form dissent list for docket 7.
Motion passes with the exceptions noted.
Thank you, Commissioners. Now we'll move on to docket 8.
Beginning with case 2402851, Commissioner Alvarez.
The AT decision was sent to the claimant's correct address However, the decision was returned to TWC because the claimant's ex-wife put it in the mail forwarding request. As this was a circumstance beyond the claimant's control, and he did not receive the AT decision, the claimant's appeal should be deemed timely. Regarding the reporting and overpayment issues, the claimant was not required to perform work searches for the week in question because he had a return to work date. Additionally, after he returned to work, he reasonably stopped checking his UPS mail inbox. Under these circumstances, the claimant should not be held ineligible. Timely CA appeal, reverse the AT decision, reporting eligible, no overpayment.
I agree that the claimant's appeal to the CA should be deemed timely. On the reporting issue, the claimant did not respond to the work search log request because he stopped checking his UBS inbox. This was within his power to control. Although the claimant had received a job offer and may not have needed to look for work, he was still responsible for reporting this information to TWC by the required deadline. We should therefore deem the claimant's late appeal as timely and affirm the AT decision, reporting not eligible from March 24, 2019 through March 30th, 2019, overpayment of $507.
Deem claimant's appeal to the commission timely, reporting eligible, no overpayment.
Short form.
242-2971, Commissioner Alvarez.
We previously found that the claimant had good cause for his non-appearance. Regarding the job separation, the claimant had worked first and second shift for the client. The client informed him that he would be moved to the third shift. However, the claimant was unable to work the overnight shift because he cares for his minor child, and because the claimant has medical issues, which would be negatively affected by the overnight shift work. After ending his assignment, the claimant reported for a reassignment, but no additional work was available. Therefore, the claimant had good cause to quit because of the offered shift was not suitable, and he reported to the reassignment he should be qualified for benefits. Reverse the AT, the claimant had good cause for his non-appearance, no voluntary leaving, no overpayment.
We should modify the appeal tribunal decision. On docket 5, we voted on the good cause issue. As to the job separation, the claimant may have had issues with the client's company supervisor. However, by quitting without advance notice and without giving the employer an opportunity to address his concerns, the claimant quit without good cause connected with the work. In addition, since the disqualification is appropriate, the resulting overpayment is also appropriate. We should modify the AT decision. The claimant had good cause for his non-appearance, voluntary leaving, overpayment of $452.
Modify the AT. Claimant established good cause for AT1, voluntary leaving, overpayment.
Short form dissent.
242-7688, Commissioner Alvarez.
The decision is not supportable. The fax confirmation pages provided by the claimant shows that he attempted to file a timely appeal but was unable to do so because the fax machines in the appeals department did not answer. The commission provided written instruction what the claimant could appeal by fax, but then the option was not available when he attempted to timely appeal. Despite these issues, the claimant did not sit idly by. He sent in his appeal the following day. Because the claimant attempted a timely appeal and the failure was in the TWC equipment, his petition to reopen should be deemed timely. With regard to the good cause issue, the claimant missed the AT1 because he had a new job and he did not want to jeopardize his job by requesting time off to participate in an AT hearing. Consistent with longstanding commission precedent, the claimant had good cause for his non-appearance. Deem claimant's petition to reopen timely. Claimant had good cause for his non-appearance and resubmit.
We should affirm the appeal tribunal decision. The claimant's petition to reopen was late. The claimant submitted evidence of 2 attempts to fax his appeal after 11 p.m. on the date of the appeal deadline, yet failed to prove that either of his attempts were successful. Because the claimant could have submitted his appeal using another of the acceptable methods we prescribed, and since there is no good cause exception to the timeliness rules, the claimant appeal was not timely, and we do not have jurisdiction to consider the underlying merits. Accordingly, we must dismiss the claimant's appeal as late and affirm the AT decision. The claimant filed a late petition to reopen, leave the underlying AT decision in full force and effect, misconduct, and overpayment of $3,933.
Affirm the AT, untimely petition to reopen misconduct, overpayment.
Short form dissent.
242-7713, Commissioner Demerson.
The AT decision should be modified. Under the terms of the employer's contract with its client, employees who are arrested for criminal charges are not eligible to work if they, number one, negotiate a plea deal on the charge, or number two, enter a plea of guilty to get the case dismissed. Both conditions were triggered in this case. The claimant, who was arrested for domestic assault, negotiated a plea deal to have his case dismissed upon the completion of a court-ordered violence prevention program. Documentation and evidence shows that he also entered a plea of guilty, which is a common requirement for defendants who seek conditional dismissals of their criminal charges. The claimant's actions led to a negotiated plea deal, rendering him ineligible to continue working for the employer. Since the claimant failed to handle his personal life in a way that would not affect his work, he mismanaged his position of employment, and we should modify the AT decision. Misconduct, no chargeback, sever the adequate response. In the alternative, since the employer had to let the claimant go to avoid a breach of contract, I would agree to a vote of no misconduct, no chargeback, separation was urgent, compelling, and necessary, and set aside the adequate response ruling.
I'll hold off on this. Thank you. I would agree with Commissioner Demerson with pay and protect.
I concur.
242-9103, Commissioner Alvarez.
The MR should be granted, and the severance disqualification should be reversed. The claimant signed a contract in 2017. If the claimant worked through the transition period, then the employer was obligated to pay the claimant a lump sum. The money that the claimant earned by meeting the terms of the contract through her work over a 2-year period should not be considered disqualifying dismissal or separation income. Grant the MR, no severance disqualification.
The MR should be denied. The claimant did not provide new evidence. To the extent that any information is new, the claimant did not offer a compelling reason for not offering the evidence earlier, nor did she provide a specific explanation as to how it would change the outcome of the case. Since the claimant has not met the 3 required criteria for a successful MR, the claimant's motion for rehearing should be denied.
Deny the motion for rehearing.
Short form dissent.
243-7779, Commissioner Alvarez.
The AT decision should be modified. I am not disputing the ruling on the good cause issue. On the merits, the claimant worked as an independent contractor for a company on 7/4/2019, and then she named that company as her last work on her continued work claim for that week. Commission presidents have long held that independent contract work can be named as the last work on a claim. The company in question responded to the notice of claim and agreed that the claimant worked as an independent contractor for it. The claimant correctly named her last work and should not be held liable for overpayment. Modify the AT no good cause for the non-appearance at AT1. Claimant named the correct last work. Continued claim dated 7/6/19, not voided, no overpayment.
I would affirm the AT decision. On the good cause issue, the claimant's failure to check her mail in a timely manner did not provide her with good cause for a non-appearance. As to the last work issue, there is no indication that the AT1 decision should be disturbed, since the evidence supports that the claimant did not name her correct last employer on her continued claim. As such, we should affirm the AT decision. The claimant did not have good cause for a non-appearance. The claimant named the incorrect last work, an overpayment of $3,042.
Reverse the AT. Claimant established good cause for AT1. Resubmit.
I would agree with the chairman. Got it.
We'll resubmit the case.
243-7991, Commissioner Demerson.
The appeal tribunal decision should be reversed. The employer expected the claimant to return to work and had assigned her at least one course to teach for the upcoming semester. However, the claimant resigned shortly before the semester began. Since the employer scheduled the claimant for further work, thereby clearly establishing that it desired the working relationship to continue, the claimant's act of resigning for a personal reason was without good cause connected to the work. We should therefore reverse the AT decision, reimburse the employer, not billed.
The decision should be affirmed. The claimant was separated at the end of the semester. As such, the claimant was separated due to a lack of work, and the employer should be billed.
Reverse the AT, reimburse the employer, not billed.
Short form dissent.
243-9467, Commissioner Demerson.
The appeal tribunal's good cause finding is supportable. The employer did not appear at AT1 because the company president did not know about the hearing due to non-receipt of the notice. The president asked employees about the hearing packet, but it was apparently not received. Speculation by the employer about what might have happened to the hearing packet does not constitute credible and persuasive evidence of any fact. Accordingly, because the employer did not receive notice of the hearing, the employer established good cause for its non-appearance, and the case should be resubmitted for merits testimony.
The decision should be reversed. While the president of the company testified that he personally did not receive the hearing notice, his testimony that one of his employees probably maybe misplaced the notice after it was delivered did not overcome the presumption of receipt. Because the employer's mail handling procedures are within the employer's control, the employer failed to establish good cause for its non-appearance. With regard to the job separation, the claimant had good cause to quit. The employer failed to pay the claimant in a timely manner on 6 occasions. It took 3 months, a wage claim, and an order from the Texas Workforce Commission for the employer to honor the claimant's last paycheck. The employer's repeated failures to comply with the law regarding the pay days provided the claimant good cause to quit. Reverse the AT, no good cause for the employer's non-appearance, no voluntary leaving, chargeback.
Reverse the AT, employer did not establish good cause for AT1, no voluntary leaving, chargeback.
Short form dissent.
244-0966, Commissioner Alvarez.
The AT decision is not supportable. The claimant called for the AT1 hearing at the correct time in his time zone. He did not realize that the hearing time was in a different time zone. In accordance with long-standing commission precedent, because the claimant resides in a different time zone and he called at the correct time in his own time zone, such a mistake is good cause for their non-appearance. The claimant had good cause for his non-appearance and resubmit.
The appeal tribunal decision should be affirmed. The claimant did not participate in the hearing because he misread the hearing notice. As such, he did not have good cause for his non-appearance. Regarding the job separation, the available evidence establishes that the claimant quit his job via text message and without giving the employer an adequate opportunity to address his concerns. Accordingly, the claimant quit without good cause connected to the work. We should therefore affirm the AT decision. The claimant did not have good cause for his non-appearance, voluntary leaving, no chargeback.
Reverse the AT, claimant established good cause for AT1, resubmit.
244-6065, Commissioner Alvarez.
The record in this case was not adequately developed on the timeliness of the petition for reopening. The hearing officer essentially took no testimony relevant to the timeliness issue. The findings and conclusions made in the AT decision are not supported by any evidence. The case should be reheard to adequately develop the record.
We should remand this case and agree with Commissioner Alvarez.
I concur.
I ask for rehear.
We can rehear or remand.
Rehear.
Rehear?
Good.
We'll rehear the case.
244-8500, Commissioner Demerson.
The appeal tribunal decision should be reversed. First, as to the good cause, the claimant did not check her mail the day of the hearing. As such, the claimant cannot say with certainty that the hearing notice was not in her mailbox in time to participate and has not established good cause for a non-appearance. As to the job separation, the available evidence establishes that the claimant violated the employer's policy regarding a patient who needed to use the restroom. Even if the claimant had not been on a final warning for job performance issues, the final incident was sufficiently egregious to warrant termination on the first offense. We should therefore reverse the AT decision. The claimant did not have good cause for her non-appearance, misconduct, no chargeback, adequate employer response.
The decision should be affirmed. The claimant regularly checks her mail, and she checked her mail the day prior to the AT hearing, and the hearing notice was not there when she checked her mail. The claimant's delayed receipt of the hearing notice provided her good cause for her non-appearance. With regard to the job separation, the director who testified for the employer provided only hearsay testimony, and much of his testimony was sworn to be inaccurate at the AT2. The employer had 2 opportunities to provide firsthand witnesses and the video that allegedly supported its case, but they failed to do so. The claimant has consistently and credibly denied the employer's allegations under oath. The claimant's sworn testimony carries greater weight than the hearsay offered by the employer. The evidence does not establish misconduct connected with the work. Affirm the AT claimant had good cause for their non-appearance, no misconduct, chargeback.
Affirm the AT claimant established good cause for AT1, no misconduct, chargeback.
Short form dissent.
2449074, Commissioner Demerson.
We should modify the appeal tribunal decision. I agree the claimant had good cause for her non-appearance. As to the job separation, the employer presented 2 first-hand witnesses who testified as to the claimant's practice of belittling, humiliating, and name-calling employees. This was inappropriate and unacceptable behavior from a manager and prompted the employer to take immediate action to discharge the claimant. Because the preponderance of the credible evidence established that the claimant behaved in the manner alleged, the employer has met its burden of proving the claimant mismanaged her position of employment. Thus, we should modify the AT decision. The claimant had good cause for her non-appearance, misconduct, warrant the chargeback ruling. In the alternative, if my fellow commissioners feel that more evidence is needed, we could rehear this case for testimony from the employer's witness who was unavailable to testify due to being in the hospital at the time of the hearing.
The decision should be affirmed. Because the claimant was working and unable to attend the AT1, she established good cause for her non-appearance. With regard to the job separation, the claimant denied that she called any of her employees names. The employer's witnesses provided vague and inconsistent testimony. Therefore, the claimant was clearly acting within her job description as a manager when she criticized the work ethic of employees avoiding customers and the quality of some of the work that was produced. The evidence is insufficient to establish misconduct connected with the work. Affirm the AT claimant had good cause for her non-appearance, no misconduct, void chargeback ruling.
Affirm the AT good cause for claimant to miss AT1, no misconduct, void chargeback.
Short form dissent.
2452167, Commissioner Alvarez.
The AT decision should be modified. On the good cause issue, the AT correctly ruled that the claimant had good cause for missing the AT1 hearing because she did not receive the notice for the hearing. On the work separation, the claimant was accused by someone to whom he had issued a parking citation of giving the man a stack of envelopes to put on his vehicles to avoid future parking tickets. The claimant had consistently denied this allegation, and the accuser's testimony was not offered in the hearing. In the week before his discharge, the claimant issued multiple citations to the man and his employees, which explained the envelopes in his possession. Moreover, given the claimant had issued multiple citations to the man and his employees, he obviously had a reason to make a false accusation against the claimant. The employer did not meet its burden of establishing misconduct by the claimant. Modify the AT, claimant had good cause for their non-appearance at the AT1, no misconduct, bill reimbursing employer, void adequate response issue.
The appeal tribunal decision should be modified. The claimant stated that the hearing notice was sent to his correct address of record, that multiple people checked the mail, and that in some instances his mail is thrown away. In addition, the claimant also stated that he was not checking the mail because he was away from his residence living elsewhere. These statements reflect that a person is not checking his mail as opposed to credible and persuasive testimony of non-receipt. As such, the claimant did not have good cause for his non-appearance, and his termination for failing to follow the employer's ethics policy constitutes work-connected misconduct. We should therefore modify the AT decision. The claimant did not have good cause for his non-appearance, misconduct, reimbursing employer, not bill, sever the adequate response. However, if the claimant is found to have good cause for his non-appearance, he should still be disqualified from benefits. The claimant provided inconsistent information regarding the citations he did or did not issue, which cast doubt on his credibility. Accordingly, the employer's evidence that the claimant violated the employee's ethics policy and was therefore subject to immediate termination should be given greater weight. We should therefore modify the AT decision. The claimant did have good cause for his non-appearance. Misconduct, reimburse an employer not bill, sever the adequate response.
Modify the AT. Claimant did not establish good cause for AT1 misconduct, reimbursing employer not billed, sever adequate response.
Short form dissent.
2454400, Commissioner Demerson.
We should modify the appeal tribunal decision. Because the evidence established that the claimant's medical condition was a factor in the job separation, the claimant should remain qualified for benefits and the employer's account should be protected from charge under medical separation analysis. We should therefore modify the AT decision. No misconduct, no chargeback, separation caused by the claimant's medically verifiable illness.
I would agree with Commissioner Demerson.
I concur with Commissioner Demerson.
That's the end of the pulled cases for docket 8. You will now receive the UI short form dissent list for docket 8.
Thank you, sir.
I move we accept staff recommendations on the remaining UI cases on docket 8.
I second the motion except for those cases which I am dissenting, as reflected on the UI short form dissent list for docket 8.
I concur with the chairman's motion except for the cases on which I'm dissenting is reflected in the UI short form dissent list for docket 8.
Motion passes with the exceptions noted. Thank you. This brings us to the end of agenda items 3 through 7. Let's take a brief break to reset for the rest of the meeting. Okay, let's come back. This is agenda item 8. Discussion, consideration, and possible action regarding the acceptance of pledges for board contract years 2018, 2019, 2020 child care matching funds.
Okay, it's on. I usually have a sign here that says turn on microphone. Okay. Good morning, Chairman Daniel, Commissioners, Mr. Cerna. For the record, Travis Weaver, Workforce Division. Annually, local workforce development boards submit local match pledges to secure federal child care funds pursuant to Commission Rule 809-17. This will no longer be a standing agenda item as boards have secured local match targets for BCY 2020. Today, staff requests Commission acceptance of child care pledges for donations, transfers, and certifications of expense for BCY 20 in the amount of $6,219,293. And I'll be happy to answer any questions.
Comments or questions?
No, Chairman.
Do we have a motion?
I move that we accept child care local match agreements in the amount of $6,219,293 for board contract year 2020 as discussed by staff.
Second.
I concur. We're unanimous.
Thank you.
Thank you. This is agenda item 9, discussion, consideration, and possible action regarding the report to the governor and legislative leadership offices concerning the estimated unemployment trust fund balance pursuant to Texas Labor Code Section 204061, the estimated employment trade investment holding fund balance available for transfer pursuant to Texas Labor Code Section 204.123.
Good morning, Chair,
Good morning.
Commissioners, Mr. Cerna. For the record, Chris Nelson, Chief Financial Officer. This morning, I'll be presenting to you and updating you on the Unemployment Insurance Trust Fund and trends regarding the benefits paid as of February 10, 2020. The trust fund balance is projected to be approximately $1.965 billion as of October 1st, 2020, which is still above the floor approximately of $1.18 billion, but slightly down from last month's projections. Although the 6 weeks average initial claims compared to one year ago, six weeks average is slightly down by 2.1%. We have seen an increase in initial claims since September of 2019, which is a factor in the slightly lower trust fund estimate. So we'll continue to monitor that. And then Commissioner Demerson, you inquired last briefing about the industries that make up the majority of the chargebacks, basically. And historically, construction, administrative support, professional, scientific, and technical services, and manufacturing comprise the top 4 of those industries, and that they make up typically about 50% of all chargebacks. And that's consistent with what we see in 2020 so far this year as well. And that concludes my remarks. I'll be happy to answer any questions.
Comments or questions?
No, Chairman.
Chris, thanks for digging into that for us.
Thank you. So agenda item 10, discussion, consideration, and possible action regarding proposed revisions to the Vocational Rehabilitation Services Manual, Chapter C1402, Transportation Services.
Good morning, Chair. Good morning, Chair Daniel.
Morning.
Is it on? Commissioner Alvarez, Commissioner Demerson, and Mr. Cerna. For the record, I'm Carlene Geiger for Vocational Rehabilitation. This morning, I'm bringing for your consideration and approval proposed revisions pertaining to transportation services in the Vocational Rehabilitation Services Manual, VRSM. Transportation is a service for VR applicants and eligible customers who need transportation services assistance to access other VR services. VR is proposing to revise current policy and procedure in the VRSM to adopt the same mileage reimbursement rate for VR customers driving their private vehicle as we do for third parties who may provide transportation to a customer using a private vehicle. VR is also proposing to establish the mileage rate for providing transportation for all private vehicles based on the mileage reimbursement rate published on the Texas Comptroller of Public Accounts website. Finally, VR is proposing to clarify in policy that except staff at the Chris Cole Rehab Center, VR staff may not transport customers. Staff is seeking the Commission's approval to proceed with these policy revisions. Do you have any questions?
Comments or questions?
No, sir.
None. Do we have a motion?
I move that we revise the VR policy to set the mileage rate for providing transportation for all private vehicles at the rate published by the Texas Comptroller of Public Accounts, and that staff must not transport VR customers as discussed.
Second.
I concur. We're unanimous.
Thank you.
Thank you. Yes.
Mr. Chairman, just to note that this is Carlene Geiger's last commission meeting. She's retiring at the end of this week after really serving the agency and the state very well. So.
Well, I mean, that being the case, should we request her to come back in 6 months with a report on this?
I think that would be appropriate.
Or should we just say congratulations, Carlene? Thank you so much.
Yes.
Mr. Chairman, they had mentioned that a while back that Carlene was going to be leaving, and I kept seeing her coming back, and I thought, well, maybe she's staying. So, false hope. So,
We'll keep an eye out next week and see if the trend continues.
Best of luck, and thank you.
Let's move to item 11. This is discussion, consideration, and possible action regarding establishment of a late refund penalty rate for career schools and colleges.
Good morning, Chairman Daniel, Commissioners, and Mr. Cerna. For the record, Carrie Ballas, Workforce Development Division. Today I bring to you the late refund penalty rate for career schools and colleges. Texas Education Code Section 132.061 requires a career school or college to pay students refunds within a 60-day period. The failure to do so requires the career school or college to pay a penalty. That section in TEC also requires that the Commission annually establish this penalty at a level sufficient to act as a deterrent to the retention of funds. Because the current rate has proven to be an effective deterrent, staff recommend that the penalty rate for late refunds to students remain at the current annual rate of 250% for calendar year 2020. Thank you, and I'm happy to answer any questions you have.
Comments or questions?
No, sir.
And do we have a motion?
I move that we approve the penalty rate for late refunds at the current annual rate of 250%.
Second.
We're unanimous.
Thank you.
Thank you. Agenda item 12, discussion, consideration, and possible action regarding the Workforce Innovation and Opportunity Act combined state plan for program years 2020 through 2023, including all core programs, the Senior Community Service Employment Program, Wagner-Pfizer Agricultural Outreach for submission to the United States Department of Labor and Education.
Good morning, Commissioners. For the record, Jason Baden, Workforce Division. The Workforce Innovation and Opportunity Act requires states to develop and submit a 4-year plan to the U.S. Departments of Labor and Education. This will be our second full 4-year plan since WIO was passed into law back in 2014. The plan before you today covers program years 2020 through 2023 for each of the 4 titles of WIOA, and also serves as the state plan for the Senior Community Service Employment Program and the Migrant and Seasonal Farm Worker Program. On November the 26th, you approved the plan to be posted for a 30-day public comment period. Subsequently, on January the 21st, you approved the WIOA performance target proposals for program year 2020 and 2021, also to be posted for a public comment period. No comments were received in regards to either of these documents. This morning, staff seeks your direction on the WIOA state plan before you to submit to the Texas Workforce Investment Council. And Commissioners, this concludes my remarks, and I'm happy to answer any questions you may have.
Comments or questions?
No, Chairman.
None. Do we have a motion?
I move that we approve the WIOA combined state plan for program years 2020 through 2023 for submission to TWIC for approval.
Second.
We're unanimous. This is agenda item 13, discussion, consideration, and possible action regarding statewide initiatives funded with WIOA, TANF, AEL, Child Care, other state level funds. Camp Code for Girls Request for Applications, RFA.
Good morning, Chair Daniel, Commissioners, and Mr. Cerna. For the record, Jennifer Troke, Workforce Division. Last year, the Commission approved an increase in funding from $600,000 to $750,000 for the Camp Code initiative based on an increased number of applications received. Per the statewide initiative standard operating procedure, we are requesting approval for the additional $14,052 in TANF funds to fully fund applicants 12 and 13 who are tied. Staff seeks your approval of these additional funds. Any questions?
Comments or questions?
I love this program, so it's the only comment I have. Great work, Jen.
Good.
Do we have a motion?
I move that we approve an additional $14,052 in TANF funds to fully fund the top 13 applicants.
Second.
Yeah, we're unanimous. Let's see. We don't have anything for discussion understanding item 14, Hurricane Harvey, so let's jump to item 15. Discussion, consideration, and possible action regarding approval of local workforce development board nominees.
Good morning, Commissioners. Mr. Temple, Courtney Arbor, Mr. Cerna, excuse me, Courtney Arbor, Workforce Division. Before you for your consideration and approval are Workforce Development Board nominations for Workforce Solutions Concho Valley, Deep East Texas, Golden Crescent, and Workforce Solutions South Plains.
Comments or questions?
No, sir.
None here.
No. Do we have a motion?
I move that we approve the board nominees for Concho Valley, Deep East Texas, Golden Crescent, and South Plains.
Second motion.
We're unanimous.
Thank you.
Chairman, I have just one comment. I'm scared for people to come to the podium because we've already lost 2 of the 6 that have already talked. So when you call them in, I get a little scared that they're all looking at Ed for some reason when they walk up.
I've noticed the same, Commissioner.
Just an observation. So I'd be scared if I were going up there, Mike.
Well, come on, Michael. It's yours.
Good morning, Chairman Daniel, Commissioner Alvarez, Commissioner Demerson, Mr. Cerna. For the record, my name is Michael Britt, Governmental Relations, and I'm not going anywhere. This week, GR is monitoring several federal hearings going on in Washington, D.C. Starting this afternoon at 2 p.m., the U.S. House and Senate Veterans Affairs Committees are holding a joint hearing to receive the legislative presentation from the Disabled American Veterans. Tomorrow morning at 9:30, the U.S. House Appropriations Subcommittee on Labor, Health, Human Services, and Education will be holding a hearing on the Department of Health and Human Services fiscal year 2021 budget request. Also tomorrow at 2 p.m., the U.S. House and Senate Veterans Affairs Committees will be holding another joint hearing to receive the legislative presentations of multiple veteran service organizations. Moving to Thursday, at 10 a.m., the U.S. House Education and Labor Subcommittee on Labor, Health, Human Services, and Education will hold a hearing on the Department of Education's fiscal year 2021 budget request. And Thursday at 10:15 a.m., the U.S. House Education and Labor Subcommittee on Higher Education and Workforce will be holding a hearing on reauthorizing the National Apprenticeship Act. This concludes my remarks. I'm happy to answer any questions you have.
Comments or questions?
No, sir.
None here.
No, thank you very much.
Thank you, Michael.
Mr. Cerna, you, nothing.
No, sir, I have nothing.
All right. Well, the time is now 10:12 a.m. The Texas Workforce Commission is now going into executive session to discuss the appointment, employment, evaluation, reassignment duties, discipline, or dismissal of the executive director, internal auditor, executive staff, or other personnel pursuant to Texas Government Code 551.074A1.